Hello and welcome back. We are going to now cover tribunals, which I think is an extremely important topic for this year because there is a lot that has actually happened with respect to tribunals. There has been a battle of sorts between the government and the Supreme Court. The Supreme Court has been giving a judgment after the other, and at the same time there have been certain rules that have been promulgated by the government. An ordinance was put into force which was then converted into a law later on, thereby making tribunals very important. So the idea is tribunals are important for two reasons. The first reason is, of course, tribunals as a whole, in terms of their independence, in terms of their functioning, in terms of their composition, right? The second reason why tribunals is also important is because there have been a series of petitions in the Supreme Court on suo motu powers of the tribunals, very specifically to do with the National Green Tribunal and generally tribunals per se. So for these two reasons, I do think tribunals are extremely important, and we must understand how should we cover this. So when we are talking about tribunals generally, we must also look at what it is and how do we intend to sort of cover this as well as we can. So when we look at the outline of how questions in tribunals can be asked, first is we must figure out what exactly are tribunals. We should then figure out the need for tribunals. This is extremely important because once we know why we need tribunals, we will then figure out whether the tribunals are actually fulfilling the reasons why they were set up. Third, we must understand the fundamental differences between a tribunal and a court of law, an ordinary court of law or an institutional court of law. We then understand the broad constitutional provisions as far as tribunals are concerned. We will then embark on a journey of certain important timelines, on certain important developments, right from the establishment of the very first tribunal to the latest 2021 judgment of the Supreme Court on the appointment and the functioning and the composition of the tribunals. And then of course we will analyze the core competencies of the tribunals and also recommend certain suggestions for this. I must also tell you that I've actually done a lot of research on this. It took me about 6 to 7 hours to consolidate this material from official sources and reading detailed Supreme Court judgments, but I do think it's worth the effort because this is going to be asked in the exam in some form or another, and you could use this as examples in other thematic areas as far as polity is concerned. Now, this is the outline for a general discussion on the tribunals. Once we are done with this, I'd like to specifically focus on the National Green Tribunal because there are judicial developments on it. There are questions being raised on how the NGT functions. There has been a prior question on the Central Administration Tribunal in the context of a Supreme Court judgment on the same. Similarly, I'm expecting a question on the National Green Tribunal as well. There have also been parallel observations made by the Supreme Court on the composition and the functions of the National Company Law Tribunal and the National Company Law Appellate Tribunal. That tribunal was quashed in the middle and then was reconstituted, and that, although is an important judicial development, but there aren't questions on the competency of the Company Law Tribunal as much as there are questions on its composition and its functioning in general, and how the fact that Company Law Tribunal also needs to be working efficiently enough to largely help issues of ease of doing business in the country. Now let's understand tribunals. Now you could be somebody who has no idea what a tribunal is. You see, tribunals in one way are sort of a midpoint between the executive and the judiciary. They're like the courts. They're supposed to address dispute resolutions, but they don't necessarily comprise of judges per se, and they are very specialized in nature. These tribunals are usually set up with the force of a law, and therefore they're also called statutory tribunals. For example, the National Green Tribunal Act allows for the National Green Tribunal to exist, and so on and so forth. So that's broadly what they are. The idea of creating tribunals is that you've got faster justice, you've got cheaper justice, you've got less procedurally complex justice, and you could actually write your answers on the basis of these themes. That are disputes being solved at a faster pace? Is the cost of disputes fundamentally lesser, and of course, are they truly specialized in their own domain? So you could actually make your answers on the basis of the need or the objectives of tribunals, and that could be the structure of your questions as well. So let's start. So what is a tribunal? And I must tell you, this is going to be a slightly longer lecture because you've got a lot of things to cover. So primarily, tribunals are essentially institutions which have been set up to discharge judicial or quasi-judicial duties. Now, a judicial duty is essentially an institution which examines a question of fact and a question of law. So a question of fact is whether an incident happened or not, and a question of law is whether that incident necessarily is a violation of a law. Anybody who performs both of these functions is a full judicial authority, whereas anybody who performs at least one of these two functions is a quasi-judicial authority. Now, the fundamental idea is that our courts are already overburdened, and if you look at the National Judicial Data Grid, and that's an extraordinary dashboard that has been created by the government, which gives you a sense of understanding of how bad are things, you would understand that most of our cases, about 30% of our cases, are at least more than 20 years old, and we are in a very difficult space, and a large percentage of our cases are actually pending in the lower courts. So we need a faster, a speedy resolution of justice without compromising the quality of justice. So the fundamental objective of creating a tribunal is to essentially reduce the caseload of the judiciary, and to also bring in a kind of specialization, because as the world moves ahead, the country moves ahead. We're looking at taxation, we're looking at competition law, we're looking at environment law, we're looking at customs excise, we're looking at debt recovery. These are very specialized subject matters, and sometimes our judges, like our bureaucrats, are also generally trained. So you may not have the kind of legal or jurisprudential expertise to deal with things. So a tribunal primarily is for two reasons. One is that it should help reducing the workload of the judiciary, and second is, of course, it brings in the expertise. Now the question is, if I tell you that the tribunal is a midpoint between the executive and the judiciary, backed by, of course, the law, the question is this truly a midpoint? Because the judiciary would want the point to be here and the executive would want the point to be here, which means who gets to regulate these tribunals, what kind of members are going to be a part of this, and this has essentially been the point of conflict, and that's exactly what this is. I'll repeat this again. If this is the executive and this is the judiciary, the tribunal is supposed to be somewhere here. Now the judiciary wants it to be here, the executive wants it to be here. Whoever wants to exercise more controls, and therefore, and because tribunals are fundamentally performing the functions of dispute resolution, and dispute resolution is the function of the judiciary. The judiciary says if the executive tries to control tribunals more, it is a violation of separation of powers. The executive says if the judiciary tries to control the tribunals more, you are violating the reason and the necessity of why we think tribunals are necessary in the first place. Very interesting debate, because this is something that is truly happening all around us, but unfortunately we don't quite talk about this. Now, the idea is to put a little bit of context that the Supreme Court, and we'll do the judgments in detail, has said that there is no doubt that tribunals are at least quasi-judicial bodies, which means they should be left as independent as they can be. They should neither be completely under the control of the executive, nor should they be under the direct control of the judiciary. They should be backed by the law, and they should have an equidistant sort of a relationship between the two branches of government. And that is why the way you are selecting the members, the way the functions are being set out, the terms and tenures of the service, all of those things have to be done, right? And you could sort of compare this to judiciary as well, and an institutional judiciary, which is why one of the most foundational discussions and reforms around tribunals is the Supreme Court also has recommended this. This was also previously recommended by a parliamentary standing committee that the judiciary is always going to have and always would want, a certain say. The executive would want a certain say. The only way you can sort this out is you set up an independent commission called the National Tribunals Commission for the administration of this. Unfortunately, these recommendations have not been implemented yet. They've been discussed in the newspapers. I remember there was an article on the 17th of May in the Hindu newspaper which did speak about national tribunals, the National Tribunal Commission, so to speak. Now that we understand what exactly are tribunals, we should also now look at why do we need them. See, you require tribunals for 4 simple reasons. First, as I was telling you, to reduce the pendency of courts and reduce the workload of courts. Second, to create faster decision making and to provide, say, an institutional mechanism which is manned by legal professionals, experts who are essentially very specialized in the area. Third is to provide a degree of super specialization in the kind of disputes that are now arising in the country today, whether it's environment or armed forces or taxes or administrative issues. In fact, over specialization also sometimes. We're looking at, tribunals for censor board, we're looking at airport tribunals, we're looking at land dispute tribunals, and so on and so forth. The idea is that tribunals were originally not a part of the constitution. They were added, the idea of tribunals and the constitutional philosophy of tribunals, they were actually incorporated in the constitution through the 42nd constitutional amendment 1976, thereby telling you that there is a constitutional need, because at the end of the day you are fundamentally altering the functions of the LENJ by creating an institution which is going to be backed by the law, is going to have judicial and non-judicial members, and is going to perform similar functions like that of the judiciary, which means you are going to fundamentally affect separation of powers, which is why the only way you should technically start to do this is by making changes constitutionally, which is why the 42nd Constitutional Amendment 1976 essentially did this. Unfortunately or otherwise, this is an emergency constitutional amendment, which means that the degree of suspicion with this amendment is that it wants to sort of garner more powers to the government, which is where I think the setting of tribunals has sort of been always under a little bit of suspicion. Now that we understand this, we should now understand the fundamental differences between a tribunal and a court of law. See, the thing is, when we talk about it, a court of law is essentially a part of the traditional judicial system, whereas a tribunal has been created by a law. You don't need a law to create the Supreme Court. The Constitution itself, being the highest law of the land, creates the Supreme Court, creates high courts, creates district courts. So tribunals are a created agency. Courts of law, for example, say civil courts, they will have powers to try any matter which is civil in nature. But tribunals are always created for a very specific purpose. The National Green Tribunal cannot hear a consumer case, right? Because it's a simple question of jurisdiction. When we talk about the judges of ordinary courts of law, they are by law, by constitutionalism, supposed to be completely independent of the executive. And you have to make sure that happens. Otherwise, whether it's federalism or unitary form of it or separation of powers, all of this sort of goes for a toss. Whereas a tribunal, because it is essentially set up by a law, the tenure and the terms and conditions are often set by the government, and the judiciary can of course start reviewing it, which is what has started to happen. Always remember that in an official court of law, in like a high court or a Supreme Court, when we talk about the Chief Justices, the Chief Justice of the Supreme Court, the Chief Justice of the High Court, or any of these, okay, so the idea behind this is that the Chief Justice will always be a legal professional. That's not necessarily true. In fact, a lot of tribunals in India, who the heads of those tribunals, the presiding officer of the tribunals, essentially may be a serving or a retired bureaucrat who would have an extraordinary amount of experience in the matter, right? And that's what the case is. Now, in a regular court of law, the judge of a court of law must be impartial, who's not sort of interested in the matters directly or indirectly. But an administrative tribunal essentially is going to look at administrative issues of the government as well. So, for example, if it's the Central Administrative Tribunal and the government has decided the terms and conditions of the Central Administrative Tribunal, which is going to hear issues of central government employees, you are essentially running a very closed house, and that's a fundamental difference. Now, a court of law is traditionally bound by substantive and procedural laws as far as evidence and all of those things are concerned, whereas a tribunal is slightly more evolved that way. You don't have to stick to a very defined procedure per se, and the tribunal could work in a faster fashion because we need to largely look at a resolution of decisions. Now, court must always decide all questions objectively on the basis of evidence and materials of record, whereas tribunals look at larger policy questions also. And the judgments of tribunals sometimes may not be very strictly in accordance with the law as much as the intent and as much as the larger policy structure in it. Now, once we understand this, we must also understand how they coexist. Now, as I told you before, the 42nd Constitutional Amendment 1976 primarily added two articles, 323A and 323B. The fundamental difference between 323A and 323B is that 323A very specifically allows you to establish administrative tribunals, whereas 323B allows you to establish other tribunals. Now, tribunals which are set up under Article 323A have to necessarily be set up through a law by the Parliament, and they have to always be backed by a parliamentary action. And you could have a tribunal at the center and one for each states. Whereas when you look at 323B, this is where most of the tribunals owe their origin to. They are set up wherein both the parliament or the state legislatures can establish this. In fact, in 2010, the Supreme Court had clarified, it was the R. Gandhi versus Union of India case. The Supreme Court had very clearly clarified that legislatures, whether it is the center or the states, both have the powers to constitute tribunals on the legislative powers that the legislatures would have. For example, the parliament can make tribunals on subject matters which are in the union list. The state can make tribunals on subject matters which are in the state list, essentially creating some sort of a formality of it. And of course, you could have a hierarchy of tribunals, you could have benches and so on and so forth. Now, depending on the nature of the tribunal, so sometimes you may have a tribunal and then you may have a hierarchy where you would have an appellate tribunal as well. So the appellate tribunal is like a higher tribunal, like how there is the High Court and the Supreme Court. So you have a tribunal and an appellate tribunal. For example, the Income Tax Tribunal and the Income Tax Appellate Tribunal, right? So things like that. Now, when we look at the placement of it, depending on the nature and the hierarchy of the tribunal, they would essentially be equated either below the High Court or below the Supreme Court. So if it is a lower tribunal, then cases on appeal could go to the High Court. If it is a higher hierarchy of a tribunal, case would usually go to the Supreme Court. The general thumb rule is that usually tax tribunals or tribunals, for example, related to industry or debt for that matter, you would usually see that cases from these tribunals go to the High Court. Cases from every other tribunal, whether it is the Central Administrative Tribunal or the National Green Tribunal, they end up usually going to the Supreme Court. So to give it to you bluntly, NGT cases go to the Supreme Court on appeal, whereas tax tribunal or debt recovery tribunals cases on appeal go to the High Court. So there is a degree of integration as well. There is a degree of how both of these systems coexist and essentially help each other make better decisions. Now, there are certain fundamental advantages and disadvantages of the tribunal, and these advantages and disadvantages are directly linked to the purpose or the very objectives of setting up tribunals in the first place. Right. So the primary advantages are that it gives you a degree of flexibility, it is relatively cheaper, the procedure is simpler, and it gives you a relief to the ordinary courts who are already overburdened. The primary disadvantages of the tribunals are that it goes against the spirit of rule of law, because they would be innovative in nature. At the same time, it is often argued now that tribunals could be a violation of separation of powers, in the way that the composition and the function of the tribunals have largely been discussed. See, what happens with formal court systems is that you have a uniform procedure for civil and criminal cases, but each tribunal has its own way of going about things, which therefore creates a degree of heterogeneity. And heterogeneity in justice systems sometimes is not really a good thing, because then it creates a sense of disparity. And therefore, this heterogeneity could also lead to sometimes subject matter experts who may be leading the court. I mean, if you think about it, the arguments that we say that hold true sort of against lateral entries, that lateral entrants are specialists. They are trained in a very specific line of work. So while they're important enough to be in the inner circle, but the secretary of a ministry should always be somebody from the administrative or the civil services, because they are generalists in nature. They understand the length and breadth of it, and they probably would look at things from a 360-degree viewing angle, as opposed to the other elements out of it. So these are certain advantages and disadvantages. Now, beyond the advantages and disadvantages, there are largely two issues with tribunals. First is how independent they are and who gets to decide what they get to do. And second is, if they were supposed to really help you with pendency of cases, are they really helping you with pendency of cases? So let's understand this. See, if there is any involvement of the central government or any other government in the administrative activities of the tribunal, whether it is about the terms, the code of conduct, or any of those things, this would ultimately affect their independence. Now, the Standing Committee on Personal Grievances of Law and Justice, the Parliamentary Standing Committee, in 2015 itself had actually recommended the National Tribunals Commission, which the Supreme Court has loved, and in fact has kept on recommending and stressing that we must have a National Tribunals Commission. Whereas the second issue with the pendency of cases is this. It is that, the idea is, if tribunals are supposed to reduce the backlog of cases, but if tribunals themselves have a large backlog of cases, it is not really solving the problem. For example, a question was actually asked around March. An unstarred question was asked to the Labour Minister in the lower house, and I actually pulled that unstarred question out, in which the Labour Minister said that as of March 15th, 2021, the Industrial Tribunal cum Labour Courts had about 7,000 plus pending cases, and as far as February 28th, 2021 is concerned, the Defence Ministry was also asked this question, is that approximately 18,000 pending cases in the Armed Forces Tribunal, and as far as income tax is concerned, with about 90,000 plus pending cases, which means the tribunals are really not helping in terms of the pendency, which means we need to change the way tribunals actually function. And this is also a lot to do with the sheer lack of resources. I mean, if you think about it, the National Company Law Tribunal has only had about 30 members, while you're supposed to have 60. If you have the full sanction strength, you would essentially, if not double, at least have a 1.5x speed of resolution of cases. Now, these vacancies are absolutely concerning, because if you look at data as far as May this year is concerned, about 30,000 insolvency petitions have been pending, and once you correlate it to the Insolvency Bankruptcy Code, which was supposed to create a speedy and a faster sort of dispute resolution, when you link it to the ease of doing business index, you would probably understand that you need a faster resolution process, right? And then, of course, the standing committee that we were talking about also had noted that several other tribunals, such as the Cyber Appellate Tribunal or the Armed Forces Tribunal, have also had a very large number of vacancies. That has been the case. Right. Now, once we're done with this, I'd like to now walk you through a little bit of a timeline. Now, you must understand that the timeline that I'm going to give you is after collating about some 60, 70 pages of data. And this sort of gives you a real sense of exactly what's happening. Now, before we go through the timeline, I just want you to just listen to me carefully and understand what is the issue. First issue is, and please get this right, the first issue is the government would want a greater say in the way tribunals are appointed and how they function. The judiciary would want the tribunal to not necessarily be very close to the executive. Now, there are two major issues that have happened. The first, of course, is when we've merged a lot of tribunals, and the second is when we've abolished a lot of tribunals. The reason we've primarily done this is through the Finance Act. Now, there is a separate issue with the Finance Act because it is, of course, a money bill. And how could the Finance Act be passed as a money bill if it is essentially looking at certain policy changes? Now, if the figure in front of you seems a little too small for you to read, you can always download the PDF from the cloud drive that you would have access to, and you could sort of maximize and see. And I'm very sorry if this is too small. I can understand that this might be too small for you to read. But I'll go through this slowly and carefully, so that you really understand what it is that has been going on. So let me just change the color of the pen because we would require a different setup. The story starts in 1941, where India's first tribunal ever was established, called the Income Tax Tribunal. Then the aspirants' beloved, the Administrative Reform Commission, start kicking in. In 1969, the first Administrative Reforms Commission suggested that we should have a Civil Services Tribunal. This doesn't mean that the Civil Services Tribunal was set up immediately. It is just that a recommendation of it was made. Similarly, in 1974, the 6th Administrative Reforms Commission recommended that you should have a high-powered, specialized tribunal parallel to the high courts of the country to reduce the workload of the high courts of the country. And you must understand why, because a lot of the cases that the courts often listen to are not necessarily on grave interpretations of the law. A lot of these are largely questions of fact that have to be disputed and then ultimately addressed. Then the first golden year of sorts happens in 1976. Now, in 1976, two things happen. First, of course, is that through the 42nd Amendment of 1976, the two articles 323A and 323B get inserted in the Constitution of India, thereby allowing for administrative and other tribunals to be established. If you've gone through the PDF I've uploaded on fundamental duties and directive principles, you would find the name Swaran Singh to be slightly familiar. So the Swaran Singh committee that we often relate to just with respect to duties and directive principles also gave certain recommendations on what are the different kinds of tribunals that you could have. The Swaran Singh committee said you should have administrative tribunals, you should have an all India appellate tribunal on labor and industry, you should have land revenue and those sort of tribunals, and all of these tribunals should largely work under the scrutiny of the Supreme Court, and the committee recommended that the tribunals should be closer to the Supreme Court or closer to the judiciary than to the government. And then in the 80s, we had a large bunch of tribunals set up, from the Central Administrative Tribunals to the Securities Tribunals to the Films Tribunal, which now recently with the Cinematograph Act and the Tribunal Reforms Act, primarily with the Tribunal Reforms Act and the Finance Act, has sort of been quashed, and we don't have a film certification appellate tribunal anymore, and the Electricity Tribunal and so on and so forth. So 80s essentially saw this happening. Now, in 1986, a very important judgment, nothing to do with, and it's not just to do with tribunals, but also SP Sampath gave some very clear indications on how judicial review is, basic structure, and so on and so forth. So in the case of SP Sampath versus Union of India, the Supreme Court, with respect to tribunals, said two things. First, that the Parliament undoubtedly has the powers to create tribunals parallel to high courts, and the appointments to these tribunals must be in consultation with either the Chief Justice of India or a committee comprising of a Supreme Court judge or the concerned High Court judge, but the judiciary must largely be involved. Now, you don't have to know the technical details of what the Supreme Court recommendation was, as long as you know that the Supreme Court said that you could have tribunals, but make sure that you involve the judiciary in the appointments of the tribunals. Now, fast forward to about 10 years later, in 1997, L. Chandrakumar versus Union of India said that in this the Supreme Court said that no doubt you have the right to create tribunals parallelly to high courts because you want to reduce their burden, no problem. But if you're creating an institution parallel to that of the High Court, please make sure you treat it like the High Court, and therefore a very specific set of cases should directly be sent to the tribunals. The tribunals should be the first instance where the cases go to, in a sense saying that there should be some original jurisdiction on that count, and the High Courts could supervise it. Cases on appeal could go to the High Court. And when you're setting up these tribunals, please make sure that preference and appointments must be made of judicial members only. And it was back in 1997 where the court rather honorably said that have an independent agency to regulate all of this, and until that happens, you could have the law ministry sort of look at it. And then life carried on. These recommendations were taken into account. That in 2010, in R. Gandhi versus Union of India, and I'm sure your mind would go to the full form of R. Gandhi, and now's not the time to get into it. But in 2010, in R. Gandhi versus Union of India, the Supreme Court very, very clearly said that, the Parliament can have High Court alternate tribunals as far as the union list is concerned. We discussed this and how the states could have parallelly to state lists. Under all circumstances, the judicial members of these tribunals should always be more than the technical members. And if you're setting up a tribunal just to quickly dispose of cases, you don't need technical members because these are going to be questions of law. And if you're appointing members, these members must come with some technical knowledge, and that is why at least secretary level officers should be given appointments as members of these tribunals. And then life carried on smoothly. In 2014, the Supreme Court, under the Madras Bar Association versus Union of India case, this is where certain provisions with respect to tax tribunals were being challenged. And this is where the final leg sort of comes in which the Supreme Court gave a very exhaustive list of recommendations, which you could use as an example on judicial legislation also, to also an extent on judicial activism also, where the Supreme Court said that Indian Corporate Law Services, Indian Law Services, any of these officers will not be considered as technical members because they're essentially coming with a legal background. They're not considered to be technical and therefore don't qualify them as technical members. And they said, the Supreme Court very clearly said that the Ministry of Law and Justice should provide administrative support as much as possible and as much as it could be. And at the same time, if there is a tax tribunal, the tax tribunal should have nothing to do with the tax department. Let the Ministry of Law and Justice provide administrative, logistical, financial support to the tribunals. Let the departments not also help tribunals financially, administratively, or logistically, so that you create a further division and a separation of powers, which actually made a lot of sense. But this could then, of course, make the government rather unhappy. And in 2017, the Finance Act, which is passed in addition to the Appropriation Act of the Annual Financial Statement, was passed, wherein the government merged a ton of tribunals. We reduced the number of tribunals from 26 to 19, and the Finance Act also had a provision, I think it was in Part 16, that the central government would have the powers to make rules for these tribunals, and then later the Finance Ministry also starts making those rules, and these rules then of course get challenged in the court. Now, in 2019, now this of course means that the government is reducing and concentrating the number of tribunals and also regulating the composition of it. In 2019, in the Roger Matthews case, the Roger Matthews versus South Indian Bank and others case, the court again took a very hard line stand. They said, boss, judicial functions will only be done by judicial members. The executive cannot remove judicial members or judges who are a part of the tribunals. Third, everybody should have a uniform age of retirement. You should not make members to the tribunals for shorter periods, because then the executive would continually keep interfering. And most importantly, you will conduct a judicial impact assessment, a JIA, extremely important, like an environment impact assessment, a judicial impact assessment on the feasibility, on the utility of the tribunals. And that is it. Now in 2020, when the Madras Bar Association was of course looking at another case, in the Madras Bar Association case of 2020, the Supreme Court then said, let us also establish the National Tribunals Commission, and you should have a 5-year tenure instead of a 4-year tenure, and you should have 67 years of retirement instead of the 65. Now, this year in 2021, the Tribunal Reforms Act was passed, and before it was passed as an act, there was an ordinance on tribunal reforms, which also is questionable because it didn't require an ordinance per se. In this, a lot of the tribunals were diluted, or a lot of the tribunals were essentially finished, that they were abolished. So the Film Certification Appellate Tribunal that we were talking about was abolished through the Tribunal Reforms Act. So in 2017, you merged a few, like for example, competition law and company law would then essentially be with one tribunal called the Company Law Tribunal, right? And that's important. Now, the Supreme Court very clearly struck down the rules that were being made by the Finance Ministry in pursuant of the Finance Act, and said, boss, nothing doing. You're going to have a 50 years minimum age. Now in this, the Tribunal Reforms Act very clearly said you're going to have a 50 years minimum age, you're going to have a tenure for 4 years. So the Tribunals Reforms Act was exactly violating the Madras High Court judgment. Now, you could sort of correlate this with the fundamental rights amenability, where amendment judgment. So to say this as clearly as possible, the Supreme Court in the Madras Bar Association judgment in 2020 said you should have a 5-year tenure and not a 4-year tenure, and you should have a 67 years of retirement. In the 2021 Tribal Reforms Act, the government says nothing doing. We will have a tenure of 4 years only and a minimum age of 50 years. Now, the Supreme Court, of course, this was challenged, and the Supreme Court in 2021 itself struck this down, said nothing doing. You will not have a 4-year tenure, you'll have a 5-year tenure, and at the same time, this minimum 50 age requirement is also wrong. With striking it down because it will discourage younger lawyers and younger legal professionals to enter the adversarial or the redressal system in the country. So when you see this timeline, you understand that there is essentially a roller coaster of a ride, where the Supreme Court keeps on giving you certain regulations on this. The government in 2017 starts going anti-tribunals or concentrates tribunals or starts giving more powers to itself on regulating it. The Supreme Court starts, shooting those powers down, and the case is still going on because this issue is a very, very large issue. Now, to get into the technical details of the last phase, it is actually this phase which becomes important, because it is around this phase where things start going wrong. So probably 2010 onwards is where things become slightly heated. Okay, so now when we talk about this, we now firstly switch back to the yellow ink, because otherwise it would be cost to the eyes. So when we talk about the Tribunal Reforms Act of 2021, what does it do? It dissolves some existing appellate tribunals and transfers their functions to existing judicial bodies, mostly the high courts. The cinematograph, trademarks, copyrights, customs, patents, airports, plant varieties, and GI tribunals, they've all been abolished, and cases now will be transferred to the high courts. And they very clearly said you need 50 years minimum to become the chairperson. Your tenure of office is going to be 4 years. You retire, most members retire at 67, the chairperson would retire at 70 years. Now, there are essentially two basic issues. First is, when you abolish these tribunals, you add to the existing workload of the high courts or the agencies that you would transfer it to. Second is, the Supreme Court after this has actually said, has struck down these provisions and said the term should be 5 years, and has also said this minimum 50 years criteria doesn't work. Instead, you should have advocates with 10 years of experience who could be eligible to become judicial members of these tribunals. With this in mind, there are certain key developments which now we can look into in a sort of detail. For example, in 2017, the Finance Act happened. The government notified these rules. In 2019, in the Roger Matthew case, the Supreme Court struck down these rules and said that these rules do not meet the requirements which were laid down for judicial independence. In the earlier judgments also, the Sampath case and the R. Gandhi case, and the Supreme Court said that we can't have shorter tenures. We need to make sure that the judiciary has a stronger say, otherwise the purpose of separation of powers would be lost. In 2020, in the Madras Bar Association case, the new rules which were notified by the Finance Ministry were again challenged in the Supreme Court, because the Supreme Court was largely relying on its own previous judgments. For example, the 2020 rules had said you will have a 4-year term against 5 years, which was very clearly laid down by the Supreme Court. The Parliament wasn't just budging. So the Supreme Court suggested amendments, said that you need to have a 5-year rule and you need to have 10 years of experience, and add these in the eligibility criteria for lawyers to become judicial members. And then in 2021, now, the Finance Act, the new rules were notified this year in June. Now, the government was nice enough. They agreed to some of the directions of the Supreme Court and said, all right, 10 years and above advocates are eligible to become judicial members, and said we will give you certain benefits for it. However, it still stuck to the whole 4-year rule. Now, this finance rules was then, of course, challenged in the ordinance. The Tribunal Reforms Ordinance was also challenged in the Supreme Court. The Supreme Court clubbed all of these matters, and the Supreme Court struck down provisions relating to the 4-year tenure and the age requirement. So these are your broad developments. So now what has happened is the Supreme Court has put all of this together, and the Roger Matthew versus South Indian Bank Limited case is now a very, very big issue which is being currently discussed. And it is looking at every possible discussion that there is. That first, the Finance Act, which was passed in 2017, does it violate Article 14 and 21? Because you're treating tribunals differently than other forms of law, and other forms of law addressing mechanisms, thereby creating an unreasonable bias. Second, how did you pass the Finance Act as a money bill when you're making such important policy changes? And third, when you add provisions of the tenure and terms in the Finance Act and these rules, are they violating the independence of the judiciary? To which the Supreme Court has broadly given certain answers to this. The first question that the Supreme Court raises is that if the Speaker certified the Finance Act as a money bill, can the court review this? The Supreme Court said yes, of course. Second, if the court can, then was the Speaker right in calling the Finance Act a money bill when it was essentially doing things other than what the money bill is supposed to do? To which the Supreme Court has referred this to a larger bench, and of course there has not been a judgment on this yet. This is currently sub judice. And third, even if it was a money bill, did the legislature excessively delegate its powers to the executive? The answer is no. The Supreme Court said you have the powers to give it to the executive. We don't have a problem. Just make sure that the powers are valid, the powers are justified. Then the Supreme Court on the fourth question said, all right, even if this part of the Finance Act, part 14 of the Finance Act, does not have an issue with respect to its legitimacy. The question is the rules that have been set up for tribunals in terms of the members and the tenures of it, are they valid? The Supreme Court categorically said, no boss, they need to be changed, which is why they brought back the 5-year tenure rule. Now, what is it that the Supreme Court said? The Supreme Court then said, the final question was, what could you further do to streamline the functioning of tribunals? To which the Supreme Court said you should have a judicial impact assessment, which it had reiterated in an earlier case also, and also recommended, for example, how tribunal should be financially independent for its functioning. This was on page 104 of the judgment, where the Finance Ministry, in consultation with the nodal ministry, will directly allocate funds. You don't have to worry about the Law Ministry anymore. Second addition to the judicial impact assessment, you should also have a financial impact assessment, figuring out what are the exact financial requirements of the tribunals. Third, the members of the tribunal shall not be treated equally like a Supreme Court or High Court judge. You don't get equivalent powers and perks. Fourth, the legislature should start consulting the Law Commission and figure out how you could reorient or change provisions for direct appeals to the Supreme Court from tribunals. What you could do is let the tribunal cases go on appeal to higher benches of the High Court, which are called division benches, instead of directly knocking on the doors of the Supreme Court, which could, of course, overburden the Supreme Court, and the Supreme Court is already overburdened. And lastly, the idea is, as much as possible, you should look at certain very specialized tribunals to be merged, because otherwise it's a lot of money that gets spent. And of course, when the Supreme Court has always been speaking about the Tribunals Commission, it is also important for you to know what is it and how should we go about it. So right now there is nothing, no information from the government. There are only suggestions to how the Tribunal Commission should be. The idea was first mooted in the L. Chandrakumar versus Union of India case of 1997, and it was very clearly said that you should have a National Tribunals Commission as an independent agency to look into tribunals and their functioning. And the National Tribunal Commission must be established by a constitutional amendment or a statute. That would be a better way to go about it. Otherwise, again, it would be challenged on the want of legitimacy. You should also look for uniform administration across tribunals, and the National Tribunal Commission could help. Thirdly, it would also coordinate administrative and judicial functions, and you could have a corporatized structure with a board, with a CEO, a secretariat, where you could really make these tribunals go-to places for faster and a very, very efficient resolution of disputes. It could also set up certain standards of performance, look at performance assessment matrices, figure out which tribunal is doing well, have an incentive mechanism for sorts. And the National Tribunal Commission could also be a recruitment body and also figure out how could people be appointed to tribunals and what kind of actions could be taken in case there are certain actions which are performed by the members which are slightly problematic. And then, of course, when we look at core administrative rules, the administrative rules would provide some sort of services to the tribunal members, the litigants, the lawyers, and they should be able to hire and supervise administrative staff to consolidate, improve, and modernize the infrastructure of the tribunals. So this is essentially what is there on as far as the National Tribunals Commission is concerned, and this takes care of it. Now, there is a larger debate because a lot of tribunals have, of course, started acting like courts, and courts are known for suo motu. And suo motu is slightly overhyped because in the last 10 years, the Supreme Court has not taken more than 50 suo motu cases. The most recent one has been, of course, the COVID litigation, which was the last suo motu case that the Supreme Court has taken recently. The question is, if tribunals are like courts and courts have suo motu powers, does that also mean that the Supreme Court, like how the Supreme Court has suo motu powers, does that also mean that tribunals should have suo motu powers or not. And if tribunals should have suo motu powers, a particularly naughty tribunal of sorts is the National Green Tribunal, and should the NGT very specifically have suo motu powers or not. The context to whether statutory tribunals should have suo motu powers or not is actually very interesting and very, very important to sort of set right. So, for example, on May 7th, 2020, last year, you may all remember the LG Polymers gas leak, where a gas leak in Visakhapatnam had basically killed about 11 people and had hospitalized about hundreds of people. The very next day, the National Green Tribunal initiated proceedings against the LG Polymers and the owners of the chemical plant. Although no one had very specifically filed a petition, this was essentially done on the basis of suo motu powers, and the NGT had taken up this on the basis of the media reports of the gas leak. Now, they passed an order imposing a fine of 50 crores on LG Polymers, and even before you send them a notice, which essentially was slightly questionable. The fine was decided based on the value of the company and the tribunal's estimates of likely damages. Similarly, in October 2018, the National Green Tribunal had passed an order on the basis of a news report imposing a 5 crore fine on the Municipal Corporation of Bombay, which is one of the richest in the world and definitely the richest municipal corporation in India, for improper waste management. And similarly, in March 2021, the NGT very recently had passed an order based on a letter written to the chairman of the corporation, and had increased the minimum distance of quarries from residential areas from 50 to 200 meters. This, of course, has had certain ramifications. All of these orders were passed by a statutory tribunal, which is essentially the National Green Tribunal, exercising suo motu powers. So what is a statutory tribunal? Essentially the same thing as a tribunal, is a quasi-judicial body, which, unlike a court of law, is an administrative institution with the power to decide cases on a defined subject matter. Now, statutory powers, or the powers of the statutory tribunals are limited to their statutory jurisdiction and are not a constitutional court of general jurisdiction, which means that they can only pass orders on things that they've been given powers to pass orders on. And what is the basic rationale behind this? The basic rationale is that the National Green Tribunal Act, for example, which establishes the NGT, does not provide the tribunal with express suo motu powers, which is why there is a discussion around it. Similarly, there are other laws which actually do. So, for example, the Karnataka Land Reforms Act of 1961, there are limited suo motu powers which are mentioned in section 122A of that very specific law. Similarly, the Debt Recovery Appellate Tribunal very clearly says that the Debt Recovery Tribunal does not have suo motu powers because it is not being given in the law, which is the Recovery of Debts Due to Banks or Financial Institutions Act of 1993, and therefore you could not enforce, or you could not infer the same and say that just because it does not mention it, which means we could have it largely. So this is the larger discussion. All of this was actually challenged in the Supreme Court, and primarily the NGT suo motu matter, and therefore the Supreme Court later on also gave a judgment saying that the NGT actually has suo motu powers, and therefore possesses a larger question that if the NGT does have suo motu powers, do the other tribunals too? Which is why let us first look at NGT and then we'll figure out the suo motu powers of the NGT. Right. So the National Green Tribunal was essentially established in 2010 for issues which were related to the environment. It has jurisdiction of all civil cases involving substantial questions of environment and enforcement of any legal right with respect to the environment. Now, it is very, very special because India is only the third country after Australia and New Zealand to have a dedicated tribunal to do so. The principal bench of the tribunal is in Delhi, and you have regional benches in Pune, Bhopal, Chennai and Calcutta, and appeals from the National Green Tribunal are are sent to the Supreme Court. Now, what are the basic problems? The basic problems are, first, the two important acts, the Wildlife Protection Act of 1972 and the Forest Dwellers Act of 2006, they've been left out of NGT's purview, which sort of restricts the very jurisdiction of the NGT. Second, it is not very clear as to the position of NGT with respect to their respective high courts, wherein a lot of NGT decisions have been challenged in the states, in the respective state high courts under 226, despite NGT very clearly saying that your appeals should go to the Supreme Court. Third, the NGT decisions are often not completely complied by the stakeholders, and therefore this becomes a questionable body in terms of its implementation. And fourth, the NGT itself also has a lot of human resources and financial resources problems, which is why it's not able to create that expeditious resolution that it was supposed to do. And that is why the objective which was set to have NGT in the first place, that you will dispose of environment cases within 6 months, still has not been done. With all of this in mind, the NGT still has done an exceptional job. If you look at some of the landmark cases, for example, the Betty Alvarez case, wherein even a foreign national can approach the NGT. Second, the Almira Patel case, wherein the NGT completely banned open burning of waste on lands. Third, in the Manoj Mishra case, where the Art of Living Foundation was penalized about 5 crores for damaging the Yamuna River when they were conducting a World Cultural Festival, which was attended by the who's of who of the country and of course the world. This is in the pre-pandemic era. So the question is, now NGT also has started exercising suo motu powers. So the question then arose, and it was from the LG Polymers case, where the petitioners had challenged that the NGT does not even have suo motu powers to begin with, and therefore the Supreme Court very recently, about 2 months ago, in the Municipal Corporation versus Ankita Sinha case, very clearly said that the National Green Tribunal has suo motu powers. And the reason that the Supreme Court gave are the following. The first is that the NGT was essentially formed to protect the right to environment, which is an implied fundamental right of the right to life under Article 21. Second, Section 14 of the NGT Act states that for the NGT to be able to hear a matter, there must be a civil case, must substantially concern the environment, and must involve the interpretation of an environmental law. If all of these three things are satisfied, then the NGT can take up a suo motu matter, because you are fulfilling the reasons as to why you were established. Thirdly, the role of the NGT goes beyond dispute resolution. It goes beyond just solving environment disputes. It also has a larger role to evolve the way the country looks at environment policy and redressal. And fourth, the court very clearly said, as long as the NGT is not giving you an order on a subject of law which is not covered under NGT, it's fine. You're essentially doing what you're supposed to do. And therefore, the NGT is finally guided by the principles of environment justice and equity. So anytime there has been a breach of this, the NGT will step in, and the NGT will make sure that adequate decisions are made in the right amount of time. And this is essentially what NGT does. Right. So this is it. This is all you need to know as far as tribunals is concerned, NGT is concerned, and suo motu powers of the NGT is concerned. And you would not need anything else beyond this. Thank you for watching.